Suit number LD/ADR/5224/2023. Adisa Lawan Keshinro Esquire versus Top Notch Integrated Solution. Mr. Bodun Akinyele, Madam Folusho Akinyele, Mr. Ayo Olubani. Claimant present. First, second, and third defendant absent. Fourth defendant present.
With profound humility, my Lord, Dr. Charles Mekunye. My Lord, Mekunye is spelled M-E-K-W-U-N-Y-E. My Lord, I appear for the claimant. Appearing with me are my learned friends, R.O. Akiode and Mary Ozioko, O-Z-I-O-K-O. Most obliged, my Lord.
Respectfully, my Lord, Bola Olubani appears for the defendants.
My Lord, this matter is for trial. The claimant is to reopen his case for a limited purpose of tendering. Yes, my Lord. The claimant is to reopen his case for limited purpose of tendering the certificate pursuant to Section 84 of the Evidence Act. My Lord, the claimant is in court. And we are ready to proceed.
NSC already informed the Honorable Court that the claimant wishes to rely on evidence already adduced.
Yes, my
That's
Lord.
why the matter is for continuation of trial.
Yes, my Lord.
And not for trial de novo.
Yes, my Lord.
Mr. Bola Olubani, are you ready?
I'm ready.
Please proceed.
Mr. Adisa Lawan Keshinro Esquire.
Yes, my Lord.
Are you a Christian or Muslim, sir?
I'm a Muslim.
You want to affirm or you want to swear the
I
Bible?
will swear by the Quran.
With the Quran, sorry.
I-
Can you read it properly, sir? The front side of the Quran. Okay.
I, Adisa Lawal Keshiro, legal practitioner, do solemnly swear that the evidence that I give in this matter shall be the truth, the whole truth, nothing but the truth, so help me Allah.
Sworn on Holy Quran in English language, my lord. Listen to the cautionary words, sir.
Yes.
You are hereby cautioned that if you tell a lie in your testimony in this proceeding, or willfully mislead this source, you are liable to be prosecuted, and if found guilty, you'll be seriously dealt with according to the law. Do you understand the cautionary words?
I understand.
Witness has been cautionary.
Witness, you were in this court on the 28th of January to swear to a further witness on oath. Am I correct? Yes, sir. If you see it, can you identify it? I will. Yes, my lord. This is the statement on oath which I swore to at the registry of this court on the 28th day of January 2025.
The signature on the witnesses.
As the witness informed the court that he wants the court to rely on.
My lord, we are relying on the statement as.
No, the witness, as the witness informed the court.
Okay, what do you want the court to do with the witness? My lord, I will be relying on my further witness statement on oath before this court as part of my evidence in chief.
Well, my lord, the observation is that this further witness statement on oath is dated the 28th of January 2025. The one I was served is dated the 10th day of February 2025, and the signatures on both, the one in my possession and the one sought to be tendered, are different.
Okay. In any case, we are relying on the witness on oath tendered, sworn to on 28th of January 2025. The witness is right in the witness box. He has said that this is his witness on oath. The issue of signature is completely irrelevant.
My lord,
I want to check with your copy.
my lord,
Register, please pass the the court copy that is relevant. Let me just see what
The document is that
it means that I was not served the one sought to be tendered.
yes. And please pass the one with the short of The further witness statement on oath before the court is the same with the claimant's copy and that of the defendants, just that the date on the defendant's copy is 28th of January 2025.
And the signatures are...
You see, I'm not...
The statement is relevant.
I'm not
Completely relevant.
but the signatures appear regular.
appear regular, my lord, but I was not served.
Okay, we can give a copy if that's your complaint. These are not
Yes, sir.
the same thing.
Let me see what I see. Can I see it?
My lord, we'll give you a copy.
Yes, sir.
My lord, I'm looking at the averments. My lord, I will not be opposing you.
Just a moment.
Yes, my lord.
Ruling, the further witness statement on oath of CW1 sworn to on the 10th of February 2025 is thereby accepted as part of the testimony of CW1 in this.
But my lord, what we have is the one for 28th of January. That's the one we have.
28th of January,
Yes.
the one I have is dated was sworn to on the 10th of February 2025.
Just for the record, because it's the same thing, practically the same thing. I think we have issue
No,
of
please,
dates.
let's clarify it.
Yes, but
Because that copy
Yes.
that NSC gave to Mr. Alugbani,
Yes.
the copy with the court was sworn to on the 10th of February 2025, and that date aligns with the date of filing.
Yes, my
So
lord.
there's no way the court can rely on the one dated 28 January 2025.
As God
Stop with this. Since they are the same, I'm not going to deliver that. My lord, on witness. You also came to court on the 3rd of December 2024 to depose to a certificate issued pursuant to Section 84 of the Evidence Act.
Very well.
If you see it, can you identify it?
Yes, my lord. I can identify the certificate issued pursuant to Section 84 of the Evidence Act 2011.
What's the one the court agreed?
I want the court to admit it as part of my
In support of your case.
yes.
It cannot be, I do want to tender it as exhibit.
Yes,
my lord. Yes,
You should make the application and not the witness.
My lord, we want...
It's not a written statement on oath, it's a
Is
certificate.
it? Yes, my lord.
Yes.
All right.
Yes, my lord. That is the purpose of reopening our case. That's just what we want to tender.
So you want the court to admit that as an exhibit?
Yes, my lord.
I'm not opposing.
No objection. Registrar. Nancy, where is the original copy of this certificate? Please return it to me. Where is the original copy? Not a written statement, it's a certificate.
Yes,
now.
certificate, yes.
It's part of the, it's a document, so to be relied upon in the suit.
Yes, my lord.
It's a secondary evidence, not admissible, sir.
My Lord, this what we have is this one we have in the file. Take the file. You have the new one.
My Lord,
It's not a certificate.
It's not just a certificate.
my Lord, sir, if I may just observe, the date on the certificate is different from the date on the further witness statement on oath. One is 2024 December, that's the certificate, and
Let me
the
take it down. Are you objecting to this certificate?
yes,
You didn't object before.
I'm amending my response now. Yes, my Lord. The certificate sought to be tendered is dated the 24th, sorry, the 3rd day of December 2024. While the further witness statement on oath is dated the 28th of January 2025. The 28th of January 2025. That's the further witness statement on oath is dated 28th of January 2025, and the certificate is dated December 2024. My Lord, the two documents should flow with each other. A certificate issued before deposition So, my Lord, on the basis of the fact that the documents seem to be at, the certificate seems to be at cross purpose with the further witness statement on oath, I'm opposing the tendering of the certificate. One refers to the other, and they do not align. Was it an afterthought?
The further witness statement on oath before the court is dated 10th of February 2025. So you are not the 28th.
I'm sorry, I relied on the one given to me in court. So I'm referring to the one dated 10th February 2025.
Yes.
My Lord, our response is that admissibility of documents is based on relevance. My learned friend has not said that the document is not relevant. Secondly, good documents. Secondly, the further witness oath made no reference to the certificate at all. And the certificate made no reference to the further witness oath. So, issue of reference of one to the other is only in the imagination of counsel. The singular purpose for the tendering of this document is to meet the requirements of Section 84 of the Evidence Act. The issue of dates, both are dated differently, is also very relevant to admissibility. There's no provision of the Evidence Act that says that when two documents are dated separately, they should not be admitted. At best, counsel
The
can...
document is secondary evidence, that's what I'm saying.
No, my lord, we're replacing that with what our file copy. I've just detached.
So there's
The
no,
file
you didn't
copy.
make reference to that.
Yeah,
The
I've
court
not-
is still of the opinion that you're making
This
reference to
is the file
photocopy.
copy we have. When we came to file, that's what that you can, my lord can say. That's what we are replacing with the same. It's our file copy that we use. So it's not secondary evidence. My lord, so our submission is that the objection is irrelevant. It's just tended to waste the judicial time in the court. And the court should overrule it and admit our file copy of your tender.
Can I have the document, please? Are you telling, you can't tender the further witness statement or not now? Are you changing this as an exhibit? You are making, the document you are dealing with now is a certificate.
Yes, my lord.
What is this for?
That's the further witness oath that we
It
adopted.
cannot be an exhibit now.
No,
The
it's
court
not,
has
it's not
already
an
accepted
exhibit.
it.
It's not an exhibit.
Registrar,
That's fine.
please pass it to the witness.
It's not an exhibit.
Hello, sir. Hello, sir. Hello, sir. I may just, without sounding like a broken record, in paragraph 2 of the further witness statement of oath, the witness.
Just a moment,
Yes.
paragraph 2.
Yes.
Yes.
Hello, the witness deposed in paragraph 2. I certify that the transcribed copy of the text messages exchanged between the second defendant and so forth and so on. My lord, certification, certify, it certifies. There's no reference to the certificate. The foundation of the certificate is his deposition. There's no connection.
I don't understand.
My lord, the witness has certified. That's why a certificate was issued. He signed the certificate. He's in his deposition in the second paragraph. He says, "I certify." What did he certify? There's no reference, there's no nexus between his deposition and the exhibit sought to be tendered. It's just floating in the wind. And so it cannot be relevant to the proceedings.
My Lord, I think this last leg of the objection of my learned friend is laughable. It's completely irrelevant. I do not understand why you, because the word certify is used. The evidence that states a certificate issued. It's a certificate. Several Supreme Court issues on that.
The certificate is for the court.
Yes, it can be in any form. Most obliged, my Lord. I didn't go to university to get a certificate.
Ruling. The document sought to be tendered is the filed copy of the certificate made by CW1 on the 3rd of December 2024. The court sees that the certificate is a filed copy because there is an original copy of the stamp of the High Court of Lagos State Cash Office at the back page of the same. The objections of the learned counsel for the defendants further on the weight to be attached to the said certificate. Relevance governs admissibility. The said certificate is relevant to this suit. Please see section 84, subsection 4 of the Evidence Act 2011. Accordingly, the certificate made by CW1 on the 3rd December 2024 is hereby admitted and marked as J.
My Lord, that will be the examination in chief of the CW1.
Any cross-examination?
My Lord, I would love to cross-examine vigorously this witness.
Please proceed.
My Lord, that may I crave the court's indulgence for a 30-minute stand down because I'm also before your Lordship's learned brother that I have applied for a stand down from to be here because I know this matter, relative being involved, will be called first.
My Lord,
Court is minded. Just so that I can round up there and come back here further.
My Lord, I'm objecting very seriously to that application. In the first place,
Just a minute.
the ruling,
Getting vigorous.
yes, in the first place, the ruling of this court was that the claimant should open his case for the limited purpose of tendering that certificate, and that the cross-examination will be limited to the certificate that was tendered. We are bound by that ruling. And secondly, and before the Federal High Court in a different matter, and I chose to come here first. And my learned friend is my junior at the bar. He has no right whatsoever to keep me waiting for him. Besides, the third reason is that he has breached every protocol of the bar because he never approached me that he had a different matter and that he will be acting for a stand-down. I object to that. That will be keeping me here, depriving me from going for my matter in Federal High Court at the instance of my junior. I object very vigorously to that. We have started. It has to conclude here before going to the next court. Most of my
My Lord, sir, the Lordship's learned brother Justice Basho has just called my case. In response to the learned senior advocate's statements,
On point of law.
my lords, I just want to restate some facts.
No,
The
you
witness
can't restate facts.
was present
It's a
on
point
the
of law.
staircase
It's a
when
point of
I
law.
informed
You only have a right to reply on point of law.
as the court
And so
pleases.
what point of law?
My lord, 3 questions for the cross-examination if the learned senior advocate insists that I must go on. 3 questions.
Please proceed. I'm not going to deliver.
As God
it.
pleases.
Please proceed.
Now, witness, if you look at the certificate that has just been admitted in evidence. Can I have this as yours? Can I give him my copy?
Exhibit J.
Exhibit J.
Please refer to it as Exhibit J.
Exhibit J. Yes. Please, can you repeat to the court the date on the certificate?
Want me to repeat?
The
The
date,
document speak for itself. It's 3rd of December 2024.
3rd of December
2024.
2024. Yes, ma'am. Now, the processes.
That's question 1.
Yes. Processes that you filed contains an additional list of documents. I don't know whether I should avail you my copy.
I have not seen that one.
Yes. The additional list of documents. 1. That's what I want you to also.
I do not have that one.
I object. The court ruled
But
that
no,
all your questions must be
Yes.
on the admitted exhibit.
It's connected to.
There's no,
the certificate.
there's no connection. You have to address
It is
only.
about the
That's not before him.
It's
You
I
have
have
to,
a question.
It's before the court. Please, may I have a copy of the court's copy of the additional list of documents, my lord? So, please, can you kindly read out number 1, additional list of documents? Number 1.
My lord,
Just read it,
will let me
please.
please, I'm addressing the court. You have
Please
asked your
answer my
question.
question.
You have asked your question.
Please read it
I'm
out.
directing my answer to the court, not to you.
I'm the one asking the questions. You do the answering.
That's-
Please read number 1.
If I'm to answer, I will not look at you. I will look at the court. I say, my lord, the certificate here is the paragraph 1 is certificate under section 84 Evidence Act dated 3rd December 2025. That is a typographical error. Because let me complete.
You've answered my
I've
question.
not
He said
completed.
read.
My lord,
He asked for
the-
order. He said read. I'm ready.
Certificate under section 84 Evidence Act dated 3rd day of December 2025. That's all. Yes.
Now, my third question to you is that you have tendered Exhibit J dated 3rd December 2024, and you have referred in your additional list of documents to a certificate. A certificate dated 3rd December 2025. Which certificate are you referring to?
The one admitted before the court, which is Exhibit J, the one pursuant to the 3rd of December 2024, which your lordship has admitted before it as Exhibit J. That's what I'm referring to.
But you stated that it is dated the 3rd of December 2025.
That could be a typographical error.
I put it to you that
Today
you are not a
is-
witness of truth.
Today is 23rd
You
of
are not a witness of
October
truth.
2025. We are not yet in December.
Witness, you are not a witness
I am
of
a witness
truth.
of truth. And I've sworn on oath
You are
that I'm
not
going
a
to say
witness
all
of truth.
the truth. I'm
You
not
are
telling the truth.
referring to a document dated 2024, yet you are claiming to have filed a document dated 3rd December
my lord,
2025.
my lord, you answered the question. You can ask another question.
Objection overruled. Yes.
Yes, I finished.
Is that all?
That's all. No re-examination.
My lord, there's absolutely no
This one.
reason. There's no reason for any reason. Absolutely.
Yes.
My lord, that's the case for the claimant.
The claimant's case is hereby closed.
As accomplices,
Yes.
may I apply for the claimant to be the witness to be discharged?
Please, my lord.
My Lord,
I'm very quickly.
because of the situation that I find myself, it's also attending your learned brother's court. May I crave the further date for opening of the defense of the defendants?
My Lord, let me also put it on record. I have read the proceedings of this court, certified true copy that was given to us, and I have seen on it several instances where my learned friend applied for adjournments. My Lord, I have also seen all the responses and the accommodation that my Lord has given. I want to appeal to the court that the court would kindly give us 2 dates so that the defendant must come with his witnesses so that we can conclude this 2023 matter, this very straight matter, and that there will be no applications for adjournment on those dates. He must be ready to come to court and to do his case. Most obliged, my Lord.
My Lord, adjournments are within the discretion of your Lordship. Your Lordship may adjourn, extend time according to the rules of court. And if there are no cogent reasons, your Lordship will not have granted those adjournments. So, my Lord, to the extent that we pick a date,
Do you want 2 dates?
my Lord, I prefer one.
And you make judicious use of the singular dates.
My Lord, the reason I asked for 2 days is that the witness should become ready for cross-examination, and 1 day will not be enough.
My Lord, the learned
I'm just
cannot
giving
determine the way and manner that I
My
defend
Lord,
my
is
case.
subject to your discretion, my Lord. I'm just giving an advance notice.
I do my
So
own
you
job
come
within the
prepared.
rules of court and the law.
Now the turn of the defendants to do their own case.
Yes, my Lord.
And the court will play its own part.
As a complice.
My Lord, may I suggest?
What date?
My Lord, Registrar, may I humbly suggest Thursday, the 20th of November.
Not convenient, sir.
My Lord, but also because we are in the court and we are before the bar, Mr. Olugbanu, that is not the protocol. You cannot suggest any date when I'm here. You ought to come to agree a date with me. But my Lord, whatever date is convenient, my Lord, can the court guide us? Cannot be suggesting the date.
Because we don't know the state of things that regards the witness is bringing. So he will be the one to suggest dates.
Yeah, but he ought to confer with me. That's the practice at the bar.
Mr. Olubani, please confer with the NSC on the dates.
What days are you suggesting? I think it's in Wednesday. Yes, 19th is coming. My God, student is coming on the court. We will take either 19th or 20th, whichever is coming.
19th
Or 20th of November. Any of the days covenant to the court.
These dates are not convenient. Yes, ma'am.
In view of the circumstances, matter stands adjourned to the 20th of November 2025 for continuation of trial at 10 a.m.
As a court, please. Most obliged, my lord.
Most obliged.
Suit number LD/20925 WD/2025. Mrs. Kaliska Ijoma Mojoku versus Mr. Bartholomew Ikena Mojoku.
My lord, may I seek leave to require?
Petitioner present. Respondent absent.